You may call your next witness.
The people would call Angel Lewis.
So the record is clear. We're back in the record in People versus Clark. Yep. Main core.
Good afternoon, ma'am. How are you doing? Good. Just one thing, make sure we're speaking up. You have a microphone in front of you. We need to make sure that's recording and getting everything okay. Thank you. I want to start off by asking, do you know an individual by the name of Michael Clark? How do you know that individual?
I work with him and he did Peyton.
Peyton, last name Trelpa? All right. And how long have you known each of them?
Peyton for over a little, maybe over 2 years now. And Michael, maybe a year, if that.
Do you see Michael Clark in the room?
Yes.
Can you please point to him and identify minor article of clothing that he's wearing?
Wearing a black tie.
The record may reflect this witness has identified the defendant.
Record shows so reflect that. Yes.
How would you describe your relationship with the defendant?
We were cordial when he was dating Peyton, but that's just mostly it. I respected him. He respected me. I was mainly trying to stay.
I want to draw your attention back to February 11th of 2026. Do you remember that day?
Yeah.
And at that time, where did you work? Were you working that day?
I was working that night, yes.
What was your shift?
11 a.m. to 5 a.m.
What time did you get to work that day?
I got there a little early, around 10 to 10:30, to complete school work before my shift.
And just be clear, is that 10:30 at night or 10:30 in the morning? Did you observe anything happen between the defendant and Peyton that night?
When I arrived the parking lot, I put my car in the park and was facing the lot where all of our ambulances sit. And I witnessed Peyton pull up in an ambulance, quickly stop, run out of the truck and run into the building. And I observed the defendant running after her at full speed.
So let's go a little bit more into detail on that. How far away were you from all of that happening?
Yeah.
And when you say that Peyton was running, how fast?
She was as fast as she could get within short distance from our door to the door to the garage.
And what about the defendant? How fast was he going?
Full run from what I could see.
Other than the two of them running, were any of them doing anything? Or were either of them doing anything?
And then it's reaching his hand out while Peyton was going through the door.
Sort of made a gesture there. Can you describe what that gesture was?
Hand out like this.
And that's your right hand?
Sure, this is right left hand.
Okay. How far away from Peyton was the defendant when he reached towards her?
Most.
Were you able to hear if anything was said between the two of them? After you observed this interaction, what did you do next?
Tried to get my belongings, which had my work badge, so I could go into the building and find Peyton.
Did you find Peyton?
I did.
Where was Peyton when you found her?
She called me and I found her in the resupply.
Roughly how long after the incident in the parking lot, or let me rephrase this question, how long did it take you to find Peyton?
Getting into the building, maybe 3 to 5 minutes.
When you found Peyton, could you describe what her apparent emotional state was?
She was very distraught. She was shaking. She looked like she was on the verge of tears.
And I don't want you to say what exactly was said, but did Peyton say anything to you?
Yes.
Was her voice steady and calm? Was it quivering? What was her voice like? Did you observe the defendant in the resupply room at any time?
No.
Other than that incident in the parking lot, did you observe the defendant at all that night?
No.
And how do you know it was the defendant that was behind Peyton in the parking lot?
I saw his face and I recognized from the side that it was him.
How long did you have to look at the individuals in the parking lot while that incident was occurring?
40 to 50 seconds maybe.
We can have just one moment, please, Remmer.
Yeah.
I'll pass the witness.
All right, hang on I just want to make sure I have an understanding of what you're telling me. Peyton pulls up in an ambulance to one of the garage doors. And you see her do that? Okay. And at the point you see her do that, where is the defendant?
I hadn't seen him at that moment. She got out of the truck and that's when he's behind a row of trucks that we parked. The face came off.
And how long did you him for? How far from the point at which you see him to the truck that Peyton's in? How long a distance is that?
Maybe 5 to 10 feet.
So, and so the time at which you saw the defendant was that 5 to 10 feet,
Yeah.
and then he came. How do you know he was at a full sprint?
I could see him running from behind the truck. It's like when I saw him coming from behind the truck.
Okay.
He was right past me there.
Okay, but you described it as a full sprint. But right, okay, and I'm not necessarily cook, but you didn't see him in an open area sprinting, right?
There is a gate that is see-through that we have, and between the row of trucks and where I saw him, where the door is, where Peyton was trying to get in.
Okay, I get you, but when I just asked you, you saw him for a distance of about 5 to 10 feet, right? Would you agree with me that if I'm observing somebody for 5 to 10 feet, that I really can't make an assessment that they're running at full speed? Mr. Simon?
The first time that you spoke to the police about this incident was the 16th of July, is that right?
That sounds correct.
The police first contacted you then about anything you might have to say about this, is that right? And you would agree that 5 months had passed since February 11th?
Yes.
Had you reviewed anything about this case prior to talking to them about this observation of yours in the parking lot that night? Had you reviewed any writings? Had you reviewed any videos, anything like that?
Not seen any.
Judge Simpson asked you a question just now. I think I understood your answer this way, so I'm going to ask this very particularly, and if I confuse you, put your hand up and say, I don't understand. It's important. I think you said you saw Peyton from the time she had the ambulance parked pull up to the building. Am I correct on that?
Sure.
Yeah, you were in the parking lot when she moved the ambulance from the parking spot that it was in to the building?
Seeing the ambulance roll too, so.
Did you see Michael at that time in the parking lot going after somehow going after her?
She,
Okay, did you see him hand her ALR? Did you see him go up to the door, hold up the ALR and for her open the door and grab it from him that she had dropped or anything like that? Did you see that? Did you see Michael walking? I'm gonna do this pace. Watch me very carefully at this pace. Up to the ambulance where Peyton was at the truck bay. If I played you some video, I would like to see if it refreshes your recollection at all as to what you may have seen in the parking lot. Okay?
Judge, I'm gonna have to object for the purpose of refreshing her recollection. I don't think she ever testified that she didn't remember.
Oh, I think she actually did. About
That she didn't remember.
seeing Michael.
Yeah, I mean, I think she did. Kind of just, well, quite frankly, there have been two different statements. So go ahead, Mr. Chairman.
This is not very long, ma'am.
Can you?
And there's no audio, by the way. Just gonna pause real quick. You see an ambulance leaving a parking spot, right? Okay. Stay with me. Do you see an individual, right? I'm circling with my cursor who's walking.
yes,
Are you able to tell from the walk or the shape of who that is yet? Okay. Can you tell now, man?
not exactly.
Um. Can you see the time of day and the date here?
Yes,
Would that be consistent with the time of day that you were in the parking lot?
yes,
If that were Peyton in that ambulance, and if that were Mr. Clark that we saw, would that be consistent with what you observed?
exactly.
Would that be consistent with your memory as to what you observed about Mr. Clark in the parking lot?
In parking lot, yes,
Okay, and then from that bay where the car is parked now, where we last saw it, where the ambulance parked, to the gate is about 5 feet. Would you agree?
in person, it's,
Closer than me and you right now? About the same distance? Okay. Okay.
Ma'am, I'm sorry, Mr. Summer, but
Sure.
would agree that if the individual that we saw in that video was Mr. Clark, and that the ambulance that we saw pull in was the one that Peyton's in, that individual is not at a full sprint. Would you agree?
I would agree.
In fact, not even necessarily a fast walk. They're actually just walking across. Agree with that? Yes? All right, go ahead, Mr. Simon.
Your Honor, I can play some additional snippet of that video. It's fractured, unfortunately, that could tie this up. But I will admit, as I showed to Mr. Cook, there's a 30-second gap that is unaccounted for. So if I can just play another section of this for you, ma'am, which is the front end of what I didn't show you. See if it will help you identify the people involved. Actually, I'm going to speed this up. You know who that is by the Walkman and the gear?
Yeah, okay,
Okay, well, let's watch her where she goes. She running, by the way?
no, she's not.
Okay. Do you see that the lights of this ambulance came on and flashed?
Yes.
Is that consistent with the use of a key fob? And then, can you tell by who that is right there, the male at the bottom? Yeah, sorry, that's when the gap is. Right there. No offense, by the bald spot, offense, or the body posture, can you tell who that is? Okay, and that all is consistent with the very same vehicle we saw at the end that was pulling out, et cetera. Okay. Can I ask, about a different subject matter? You're Peyton's roommate, yes? And you were Peyton's roommate in the fall of 2025. And in the fall of 2025, Michael started to hang out at your place at your guys' invitation. Would you agree? I'm sorry, Peyton's invitation, and even spending the night. Would you agree? And the three of you were pretty good friends. Would you agree? Well, you referred to him as sister husband, right?
Something being started, I just go along with it to make her happy.
Oh, okay. Well, you're pretty defensive of Peyton. Is that correct or not correct?
That's what you're asking.
Well, just the way you answered that question, let me ask you this. Did you ever put a sticker on Mr. Clark's locker? Do you know who did? Did you see it happen? You ever supply information to another person about a biohazard sticker being placed on his locker? Did you ever tell anyone you did do this?
Well, Peyton that I had heard someone else that did it.
Did you tell her you did it? Do you know who? Strike that. Would you have known Mr. Clark's high school nickname? Have you ever heard the nickname Tobus? Have you ever heard Peyton circulate that to anyone else? Have you ever heard do you know anything about this case in terms of its case number? Do you have any idea what's the date on the complaint of this case? Okay. Have any idea what any of the court dates were? Have you ever heard Peyton exchange that information to anyone else, you or anyone else? Is it fair to say, being roommates, you and Peyton are like probably the closest of, she's the closest of your work friends? Okay. Thank you. I have nothing else.
Biohazard sticker, had you seen it? You have not seen it?
No.
Did management at HVA talk to you about it at all? By HR? About the sticker?
Yes.
When you were questioned, did they show you the sticker?
No.
Just questioning about the sticker never showed it to you. Go ahead.
Man, when you say you saw the defendant running, would that have been, well, let me phrase the question this way. You saw the video that defense counsel played to refresh your recollection, correct? Did that capture the entirety of what you observed? The running that you saw, when did that happen in relation to the video?
It started as soon as Peyton was going towards inside the door.
And perhaps if we need to, we can put the video back up. After the vehicle well, I don't know if I'll need it just yet, but after the vehicle comes back around, comes to a stop, were you able to see Peyton at any point at that point? In the video, were you able to see her? All right. And so it's after then that you're saying is when you saw the running?
I guess I'm trying to figure out when this full sprint was. I see in the video, we see the ambulance basically come toward the camera, correct? An individual then approaches that from this court's perspective looks like Mr. Clark, right? From my observation, but and at some point they're along the side of that ambulance, right? Is it from that point that the sprint happens?
One patient is outside of the ambulance door and halfway in the garage door to the side that's not the actual garage door. That's when trying to get closer.
Okay. All right, go ahead.
Nothing further, Your Honor. Thank you.
Anything else? Oh, yes.
One question. Distance from the door of the ambulance that pulled up to the front door of HVA. Hold on, I'm not done. I'm going to approach you and you say closer, further, okay?
Maybe up there.
Okay, and I would estimate that's about 8 to 9 feet.
Okay.
Thank you.
Anything else from either side?
No, Your Honor.
Nice step down. Thank you.
Think this witness be excused? I don't know.
I don't have to vote.
This witness may be excused.
And Your Honor, people call no further witnesses and would rest at this time.
Your Honor,
But it depends. Or you may.
Your Honor, I'm moving for a directed verdict at this time. I realize the bench trial, but this in the court. Specific. 6.419 D. It says that a judge in a bench trial can render a directed verdict, not on the traditional standard, but by saying the people's proofs didn't make it beyond reasonable doubt. Weirdly, inexplicably, in the scope rules, that rule doesn't seem to be included in the district court rules. Why? Because most of the bench trials happen in district court. I've actually talked to the SCAO. Nobody can explain the oversight. And one day before I actually die or retire, I'm going to make sure that gets fixed. But the point is, it's what I call the cut to the chase rule, because it allows a judge to say, instead of even on traditional standards of no reasonable minds can differ, look, if it's not there, it's not there. I'm asking the court to use that standard, but even the other standard, I don't think the people have met their burden. All of this requires a state of mind that somebody actually possessed the state of mind that Ms. Trelfa tried to display or tell people she had, but none of it was so. It wasn't so because the span of time from 2/5 to 2/12 really shrinks down to those 2 days and those 2 contacts. It really does. They're going back and forth on other things, including the return of his property. And she doesn't, but the way that we know I'm right, Your Honor, and what I think you can use in making and granting this verdict, directed verdict, is the cuteness in what she tried to be. What do I mean by cuteness? Playing cute, insultingly. She started that on February 22nd. I didn't think she'd dare continue to today, but she did. She told the police, we didn't date, but just for a few weeks. How his reaction was crazy. And then even she continued that in court under oath before Your Honor. And even getting to that, she tried to parse it out. Well, sexually romantic and dating is a very different thing. I called him my boyfriend in December, but we weren't dating. She still maintained that. She was cute about the presence in the locker. Didn't do that. And then when I refreshed her, okay, she didn't remember. Oh, no, I didn't leave a present for the locker because I gave it to him. Well, you started by putting it in a locker, right? Yes, that's where you intended to find. Yes. This goes to witness credibility and her true state of mind at the time. She used terms today like speed walking. Well, that's what I think it was, speed walking. When she told the police on 2 separate occasions, he chased after her. And on today, thankfully, she told the truth about February 7th. He didn't chase after her. He came up, knocked on the door, said, "Can I speak to you?" She got out and talked to him. It was just not even close to what she told law enforcement. I think that it's fair to say she played cute with your honor when you kept trying to figure out how come she contacted the police and when. And then she finally answered, okay, well, the HR told me to make the report, and she clarified as to when, but we had to poll for that information. How about this one? Did you contact him while you were on vacation? No. You sure? Didn't? No, absolutely not. You didn't? You didn't text him? No, I didn't. Well, let me refresh your memory. Oh, yeah, no. That's because my friend, whatever. I mean, she played so cute with that and tried to actually say that her reaching out to him in text messages at first wasn't really a reach out. You couldn't have been clearer in your questions. I couldn't have been clearer in the questions. All of this adds up to what her true state of mind was. In fact, what's really a tragic thing here, Your Honor, is the lack of investigation of this case that could have supported so many things. But thankfully, I think we've established them here, consistent with my opening. She was annoyed maybe a little bit, but having a broken heart and being wrongfully accused of something isn't criminal. I mean, here's a guy who had this great relationship, or he thought he did, and he's trying to talk to her and vindicate his name. And it turns out that the person who quote unquote whistle blew on him confessed. She confessed. I lied. I made the whole thing up. She's an interferer in the relationship. And how we get I say it's a 2-day period, at maximum it's a week, but it really isn't, because there weren't continuous contacts, to stalking on a criminal level. I think on the people's most favorable interpretation of the evidence, it just isn't there. But now I want to talk to that lack of evidence. There are so many points here that could have been helped by this case. The February 7 video that I was not able to get and tried, and law enforcement didn't try until April, and then they said, oh, it's no longer available. Nobody ever tried to get the February 11th video except us, and I had to go through Honigman lawyers representing HVA to get them only last night. Law enforcement has far greater authority than me, and they could have gotten that. And how about this one? The text message, the screenshot, I'm sorry. She provided all text messages to law enforcement. What about on February 22nd, it was communicated to police that she called him that night. What's the follow-up on that? Where's the evidence of that? How come nobody has to look at her phone? Because had she called him on February 2nd, Your Honor, and she doesn't deny that there's an incidence of her phone calling of her phone, she just can't explain it. That also goes to her state of mind. Lastly, Your Honor, the biohazard sticker. Okay, there was dancing around that sticker. Your Honor had a hard time getting a direct answer. I had a hard time getting a direct answer, but who could possibly have populated those fields of information other than Ms. Tralfa? Now, maybe she supplied it to somebody else to do that. But she also told us today, before I showed her anything, she expressed knowledge of every detail that was in it. The case number to the SM, the nickname, the dates, the pretrial date. And then she said she's never seen it. And then she even said that HR never told her what was in it specifically. Stop it. So, Your Honor, on any standard by which you have it, before I call law enforcement and not only ask them what they were told and why they were led to believe the case was A when it was really B, and then more importantly, what they did not do, I'm asking the court to essentially cut to the chase and grant the motion for directed verdict. This is not a credible witness, and the only thing I think you can reasonably believe is that she wasn't of the state of mind that's required by the very limited context.
But if I were to rule on your motion for a directed verdict, I have to take all of that evidence maybe rightfully or not, in the light most favorable to the non-moving party, that would be the people.
I actually think the drafters of that rule think otherwise, but I admit what I said. So-
Which rule? 4 point.
6.419, which says if
Oh.
you think the proofs aren't here beyond reasonable doubt.
Right, however,
Yeah, I understand.
you're also right as to its applicability here in district court, which just, I don't understand it myself. So,
But even still, yes, Your Honor, that's the traditional measure. And even still, I just don't think that it suffices.
Mr. Cook.
Thank you, Your Honor. I would agree that the proper standard here is light most favorable to the people under 6.001 and the applicability of the court rules cited by defense counsel. I think the court, viewing the evidence in the light most favorable to the people, could find a verdict of guilty here, frankly, based off of the text messages alone. On February 5th, the very first text message, the victim is saying, I can't do this anymore, Michael. I'm not doing this again. This is nothing but pain and suffering. February 9th, the victim again texts the defendant. I have told you once and I will tell you again, I do not want to talk to you nor have a conversation about any of this. And a little bit later that same day, I will not talk to you anymore nor text. And I expect the same again on February 9th. I will tell you once more, I do not want to talk. End of story. On February 9th, the defendant responded saying, I'm sorry that you don't want anything to do with me or this conversation, but I just needed peace. I think that's an acknowledgement that he understood that the victim didn't want to have any communication with him and that she wanted no more contact, but he persisted anyway in sending many more text messages. Again, on February 9th, the victim told the defendant, I thought I was very clear in my multiple statements of I don't want to talk. This is all I have to say. Again, please leave me alone. Fast forwarding to February 11th, the defendant admits to leaving coffee in the locker for the victim. On February 11th, the defendant also says, I'm going home. Don't worry. Not going to have to deal with me anymore. I believe that shows that the defendant had that altercation in the parking lot, while the exact nature of what happened in that parking lot on a different standard may be up for review. I think in the light most favorable to the prosecution, that the victim felt afraid of that interaction. The testimony of the victim, as well as Angel, shows that at least afterwards in the resupply room, the victim was shaking. She was emotional. She was on the verge of crying, I believe was Angel's testimony. I think on page 14 of People's Exhibit 1, the defendant says, I know you hate me for sending that. Thank you. If you read it, you don't need to reply. I know you won't. So he knows that this is causing her distress, but continues to reach out and recognizes that he's doing it for his own gain so that he can find peace while denying her peace. I believe, like most favorable to the prosecution, a directed verdict of acquittal would not be appropriate, and I would ask this court continue and hear evidence from the defense before rendering a judgment.
Yeah, the problem is that that's cherry picking. Mr. Cook was reading those February 9th messages and then he left this part out. When I said you could try and I wouldn't, that meant I'm trying not to reconcile this, and no matter what you do from now, there will be no second chances. And that string ended with, I did not understand that's what you meant by you could try. Everything up to that point, Your Honor, is an exchange that is not, don't do this. She was told him, she acknowledged, you can keep trying. I'm not going to fight for this. You can. And he did, and he tried. And after that, there's a single text on February 10th. I hope you're doing all right. Have a great day. And then February 11th, we all know what happened on February 11th. Your Honor, I don't think under any standard that meets stalking. I just, there are some behaviors that can be annoying. There are some behaviors that can be whiny and maybe, no offense to people, wimpy or whatever. When we do things with a broken heart, Lord knows, I tell clients all the time, don't make admissions. So I'm not going to make the admissions of things I've done, but it doesn't mean they're criminal stalking. That's a different standard. That's something different. And that's why I say under any standard, this should be, the motion should be. Also, I know Mr. Cook left out the whole phone call thing on the 22nd. I think if any fair interpretation of the facts is that she placed a call to my client on the very day she reported this to the police. Also,
While I'm listening to everything, the one thing that was sort of remarkable is Mr. Simon's belief that he has a heart to be broken. All right. So, what, and I do absolutely agree. Actually, with both sides, I think the standard that I have to apply is I have to take the evidence in light most favorable to the non-moving party, that being the people ruling on this. When I look at it, and while it might be slim, I think a reasonable fact finder, were they to believe certain things, could conclude that the offense of stalking, I mean, barely, it meant that, but barely, could make that finding regarding stalking, for the reasons as stated by the people. And so for those reasons, I will deny the motion, and we can proceed on. I am going to take a very brief break to decide whether or not defense wants to put on it.
that's.
So the court will stand in.
Thank you.
Are back on the record in the case of the People versus Michael Clark. Are there any witnesses for the defense?
No, Your Honor, defense.
All right, closing arguments.
Thank you.
And I'll keep this brief, as the court had just heard arguments on the motion for directed verdict. I would incorporate the arguments made there, except as it relates to the standard of proof, in my closing arguments. Outside of that, I know the court heard a lot of contradicting testimony today. Contradictions both from internally with their own testimony, as well as some contradictions between what the witnesses testified to, and contradictions between what the witnesses testified to, as well as some videos that were shown. I'm not asking the court to overlook those contradictions, but what I think is not contradicted, and frankly was difficult to contradict in general, are the text messages that were sent and the communications in real time as they were happening. I know I already went over the text messages contained within People's Exhibit 1, and while opposing counsel says I cherry-picked some of those, I was emphasizing some of them. I would invite the court, if the court feels appropriate, to read through all those messages again to get the sense that Peyton was having, and the ongoing attempts to cease this communication, this contact, that were not respected by the defendant and his recognitions thereof. As it relates to People's Exhibit 3, the text messages that Peyton sent to her supervisor when this incident, or right after this incident occurred, I think it's telling that she says, "I'm shaking and he won't leave me alone." I think that goes to her state of mind, that she really was afraid of and concerned by this defendant. I think adding in the context that she is a young, I believe she said 20-year-old woman at night walking to her rig on her own with a man, her ex, following her, who she had told not to have contact, but he's following her. I believe that would put a reasonable person in fear and would lead to that feeling of intimidation, threatening, harassing, molesting, etc. All the language that the court is aware of in the jury instructions that the people have to prove. Normally, again, I would walk through each one of the elements and what evidence shows those elements beyond a reasonable doubt have been met, but I know the court has listened very attentively to all the testimony, and the court knows all of the elements. So I would just ask the court consider all of that when rendering its judgment, and I would ask the court find the defendant guilty of stalking. Thank you.
Mr. Stein.
Just really briefly, I'm not going to repeat what I said on the motion for directed verdict, because that was essentially a closing argument. I just want to say, in terms of the last argument from the people, and if Ms. Truffa in fact communicated she was shaking, I don't know that we have to accept that that was truly occurring, or that there was really a reflection of a state of mind or fear or terror, because it could have been a reflection of the emotion of the situation that this is the second time they'd seen each other since the breakup, only 6 days earlier of a strong and steady relationship until somebody interfered with it and interfered with it in kind of a vile way. And also, Your Honor, in my opening statement, I said we got here. We got to this place because there's a great amount of embellishment. And I believe the proofs supported that. And, you know, the duration of the relationship, what it was really like, the gift giving, what it was told to the police, what it was really like. How about this one? How she got onto his shift? I'd forgotten that in my list of cute, what I say, cute things, or playing cute. That's how I phrased it. I'd forgotten that one, and I don't know how I'd forgotten that, because that one, Your Honor, is a multi-layered onion. Just to refresh the court, she didn't just say that he was responsible for the bid switch. She said that was before they were dating, false. She said she had no control over it, false, because she accomplished it. And she then said because she was only a D-lister. In other words, I couldn't do anything about that. Then, of course, she acknowledges that, yes, it was her, but she won't even answer that question. And that really goes to her credibility. And then when pressed further, she said, yeah, 2 weeks later, I did express my happiness that he did turn down the other job that would have kept us from being on the same shift. Your Honor, the true state of mind was this. It's what she said, and it's responded to the court's question. It was, I reported this to HR. They said when we got back from vacation, they brought me in. They said, you're probably going to want to make a police report. She did make the police report, but the report she made and the truth were two very divergent things. They were embellishments. And I say to Your Honor that what I said in the motion, from February 5th through 9th, he's doing what she authorized him to do, fight for the relationship. And February 10 and 11 are really why we're here. I don't think that meets, by the reasonable doubt standard, the elements of stalking, because it's not a willful course of conduct. Willful course of conduct to harass another person, and there were no threats or any other adjectives in that are in that statute. So I asked the court to find him.
Anything else?
People waive the law.
All right. The court listened very closely to the testimony. I don't think there's really an issue as to the elements of stalking and what those comprise and what they can comprise. The real question in this case is a belief by the court that what was going on here was that the defendant was indeed stalking Peyton. Yeah. Frankly put, I don't believe that the defendant had the intent to stalk her. I don't believe that the defendant, even by his actions and what he said, did indeed stalk her. I think what happened here, and I think it's probably an appropriate term that Mr. Simon put forth, that there's all of this embellishment to make it look as though this is something far beyond what it is. And it's not until this process that Peyton and, quite frankly, Lewis, in terms of some of her statements, gets called on to get called to task as to what's really being said. Mr. Simon called it being cued. I think that when you're in a court, you testify as to certain things that you indeed have to tell the truth for what it is. The contact with the police and with HR prior to vacation, when I started pointing out the dates, he began sort of obfuscating when exactly she could have contacted, somebody advising her to contact, but then she's on this vacation and she doesn't do it until at some point she comes back, and then somebody from HR does something, tells her to do that. Could have happened that way. I don't think it necessarily happened that way. I also think that had she been in great fear, HVA would have done something very different and that she would have contacted the police if she believed that this individual posed that kind of threat. But you look at what she was trying to do. Going to make this relationship as short as possible so that there's no explanation as to what might be the defendant's behavior vis-a-vis me. So that if I lessen what this was, he shouldn't be acting this way because it was really nothing. We spent all of the time questioning the length of the relationship. It was very clear that it was January. Just said January, which would have made this basically a month or a little over a month long relationship, only to find out that this relationship then went back, covered two major holidays, well, including New Year's. I mean, but just covered Thanksgiving, Christmas, certainly, may have gone back to Halloween, but certainly Thanksgiving and Christmas. And all of those things were covered. But then when caught on that, on the time, she wanted to play a game, and this is the court resented it, quite frankly, a playing game as to what kind of relationship this was. Was it a romantic relationship? Was it successful? She's kept using these words to try to again say that, yeah, while we knew each other, it wasn't that. And then finally, it just had to come down to, we spent, in my opinion, a great deal of time trying to sort that out. And the court had to specify particularly that it was it was a romantic relationship and a sexual relationship. And finally, she had to answer yes. I don't know why that couldn't have been answered at the very beginning. The exaggeration of the gifts being sent was also hugely problematic, particularly if it's relayed to the police that he keeps sending me gifts, but he's sending Valentine's gifts that he's already ordered and she knows they're coming. It's almost as though what she's doing at that point is attempting to try to set him up. That all of a sudden these gifts will come in and now he's going to have to go back and he's going to have to show that he ordered these well before any type of breakup. But quite frankly, I think that if it had come down to that, your breakup would have occurred at a different point, because I think she moved the calendar to fit what she wants to show. The other part, because I also believe that not only was this victim, and I'm not one in the victim bashing, I think that if somebody were truly the victim of stalking and somebody's doing something like that to them, that ought be clearly, it should be, that person should be held accountable. But by the same token, when somebody's attempting to try to then say you're doing these things, and this will happen in workplace relationships, to attempt to try to damage not just this relationship, which may have fallen apart and it's nothing there, but also just to damage the ability to work. Your employment, whether it be that employment, your future employment, and the like. I said the things that I'm not happy with what was said to the court, but I think they were outright lies. And I'll just put it bluntly in regard to the work schedule. Even when called on that, you listen to it, she tried to go around on that, tried to find a way out of it until, to his credit, Mr. Simon got her pinned to the point that she couldn't say anything else, but Yeah, okay, that's right. Shouldn't take that much for somebody to just tell the truth. Other problem, the bio sticker and the label. This is where I had problems both with Peyton's as well as Miss Lewis's testimony. I think they were. I don't believe for one moment that two people got called into HR, four supervisors, questioned about an item that they've never seen. That makes absolutely no sense. And I don't even know how they could then speak on it. But then you listen to Peyton, and she's going through each of the things that is on it of something that she has never seen, been questioned about, but has never seen. Do I believe that? Absolutely not. I think she came before this court. I think she lied. I think Miss Lewis was complicit in that lie. And she was going to try to do anything for whatever the reason. And I'm not saying, Mr. Clark, I don't know you. I don't know if you're an angel or not. I don't know any of that. But what was clear to me in this case is there was this attempt to try to destroy you in some way. Regrettably, in that whole thing, also is really problematic to me. All of that starts from your ex-wife. Because all of this just flows from there, and it just becomes this thing that frankly doesn't make the whole thing doesn't make any sense. Taking anything that you do and going back to Peyton, taking anything that you do when you're looking at trying to contact her regarding retrieving your property on the 12th, well, all of a sudden that turns into your stalking. No, I'm trying to get my property. I'm trying to make it clear. I'm trying to make it clear as to when I can do it and what I can do and everything. That doesn't make it stalking. I don't know that. And again, I don't know where the line is often drawn, but usually one can tell that when a relationship breaks up, parties may want to try to find a way to get it back together. I'm not even sure at the beginning of this breakup that it was a breakup. I'm glad I'm not here to call that. Because I think if you tell somebody, yeah, we've been together, but I'm mad at you about whatever I'm mad at you. I'm not working on it, but you go ahead and do it if you want to. That means you've got to somehow, what that says to me, maybe in my old fashioned way, is that says you got to somehow or another woo me. You got to win back my trust. You got to do that. And then you go about trying to do that. And then next thing you know, it's not working. And then she just says, it doesn't matter what you do. I'm going to make it clear what I meant, which I think given her testimony here, I don't think that that's what she meant at the beginning. I think it's something that changed. And it changed to try to get you to do something. Well, this court's not going to have any part of that. And, just plain and simple, she wanted to put you into the system for whatever the reason. And you had a whole lot of folks out there just mad at you. So sometimes I just say be careful. For those reasons, the court does not believe that people have sustained their burden, haven't shown, frankly, in this court's mind, the major elements of stalking. So for those reasons, the court would find that the defendant is not guilty of this charge. The defendant is further released and discharged from any further obligation to this court. Thank you.
May I approach to retrieve the exhibits?
Yes.
Maybe I'm sorry. Raymond, I'll wait for you.
Talk to your client.
They're out. Did everybody else clear out there?
Yes, everyone else was.
Okay. Okay. And that being all I have, 14A stands.
Michael Clark's trial reached its most important moment when the prosecution called Angel Lewis, a co-worker and friend of Peyton, as a witness. She testified that on the night of February 11th, she saw Peyton run from her ambulance into the building while Michael followed behind her. According to Lewis, Peyton appeared extremely emotional afterward, shaking and close to tears. The prosecution relied on this testimony to strengthen its argument that Michael's behavior had caused genuine fear and supported the stalking charge. However, the defense carefully challenged her account during cross-examination. Surveillance footage from the parking lot was played in court, and instead of showing someone sprinting after Peyton, the video appeared to show a man simply walking. When questioned about the footage, Lewis admitted that if the person in the video was Michael Clark, he was not running at full speed. This contradiction became one of the most significant moments of the trial because it raised doubts about the accuracy of her memory and testimony. After the prosecution rested its case, Michael Clark's attorney immediately asked the judge for a directed verdict, arguing that the evidence was legally insufficient to prove stalking beyond a reasonable doubt. Although the judge denied that motion at the time, saying there was just enough evidence to continue the trial, he made it clear the case was extremely close. During closing arguments, the prosecution focused heavily on the text messages. They argued that Peyton repeatedly told Michael to stop contacting her, yet he continued reaching out, leaving gifts, sending messages, and approaching her at work. According to the prosecution, those actions showed a pattern of unwanted contact that amounted to stalking. The defense presented a very different picture. Michael's attorney argued that this was not a stalking case, but a failed relationship. He pointed to inconsistencies in Peyton's testimony, questioned the timing of her police report, highlighted missing evidence, and argued that several witnesses had exaggerated key events. The defense maintained that Michael was simply trying to repair the relationship and recover his belongings, not intimidate or harass anyone. In the end, the judge ruled in Michael Clark's favor. He stated that while the breakup was emotional and messy, the prosecution failed to prove that Michael intended to stalk Peyton. The judge also expressed concerns about the credibility of some witnesses and concluded that the evidence did not meet the high standard required for a criminal conviction. Michael Clark was therefore found not guilty and released from all further obligations to the court.